So Rupert Lowe had his judicial review application killed off by a judge this week. No surprise to hunt and gather, of course, the English judiciary isn't even hiding its corruption anymore. And it's very obvious that the British establishment do not want Rupert Lowe to be the Prime Minister in 2029. We've been getting into another investigation on a story which is far and away the worst example of judicial corruption that we've ever seen. We're going to turn it into a documentary series in time if we can get proper funding, and we're going to write a book about it. The materials really are that good. It's all about a woman called Hazel Walker. Now, Hazel, back in the 1990s, she's about 60 now, I think. She won't mind me saying that. But she was living the dream back then. She had it all. She was a working class girl from Birmingham. She'd come from nothing. She'd worked her way up to very, very important jobs in the branding and marketing industry for high-end brands like Tag Heuer, Louis Vuitton, that kind of thing. She was traveling all over the world. She was hanging out with celebrities like Ayrton Senna, George Harrison, Kiki D. And she was basically living the life that all those Instagram influencers want to be living now, back in the 90s. And that's when she met Philip Hughes Walker. Now, Philip was from a very different background. He'd been born into not an old manny family, but a very wealthy family. He was very good with numbers, charismatic, a former Goldman Sachs trader, driving an Aston Martin, and by then he was working in the family business alongside his father, Rod. Now, Rod was another numbers man, an accountant, and it was 1964 when he, then working for a firm called Jackson Hesketh, had spotted an opportunity up in the northwest. There was a sand quarry business in Cheshire called Archibald Bathgate and Sons, and Rod bought it, along with his brother, his sister, and 2 colleagues from Jackson Hesketh. 5 of them. Rod started, we believe, with a 40% share. Now, by 1982, 18 years later, Rod Walker owned 100% of that company. His brother, his sister, his former colleagues, all gone. Now, how that happened, how Rod Walker came to own 100% of that company, and what became of the people who started that journey with him, is something that Hunt and Gather is looking into. If you've got any knowledge of the early history of the Archibald Bathgate Group, we'd love to hear from you. huntandgathertv@gmail.com, particularly if your name is Walker or Bathgate. Because here's what that sand quarry became. ABG is now one of the largest producers of high-grade industrial silica sand in the United Kingdom. It's a rare grade of sand, and surging global demand makes this a valuable and appreciating commodity. They put out about 500,000 tonnes a year with customers across glass, ceramics, a serious industrial infrastructure, right? But deposits don't last forever. And towards the end of the last century, the Walker family was realising that the sand upon which its family fortune was literally built was running out. Now, contrast Hazel. She'd worked her way up from a terrace in Belfast at the height of the Troubles, and now she was being courted by Cartier for a big plum job in Europe. They told her to name her salary. Instead, she went to work for the Walkers because she was in love with Philip. They made her a director of one of the companies, but she worked across the whole group on all their different companies. She did a bit of HR, a bit of promotion, a bit of this, a bit of that. That's the kind of girl she is, but she never got paid. Hazel and Philip had a daughter in 2003, and after that is when things started to go wrong. By 2007, the couple had really fallen out with old man Walker, his wife, and Philip's sister, Susan. And now, this was a very serious no-contact break, and Philip and Hazel moved to San Diego in California, and years of estrangement followed. Then in 2011, Rod Walker got back in touch. But by this time, of course, he wasn't just Rod Walker, the accountant. He was one of those rich guys who like to go around below the radar collecting honours. right? Deputy Lieutenant of Merseyside, Commodore of the Royal Naval Reserve, and High Sheriff of Merseyside. He was the Pro-Chancellor of Liverpool John Moores University for a little while, and they also gave him an honorary fellowship. And so he's very well connected, and he actually lived in a tiny little village alongside a couple of very senior judges. So why the sudden change in 2011? Well, it might have been what was going on at Archibald Bathgate. In fact, we think it probably was. Now, remember, we told you that the sand, the milk from Rod Walker's cash cow, was running out. But around 2011, it seems a new survey, work at the site, revealed significant new reserves, about 7 million tonnes, it turned out. Reserves big enough to justify a planning application. Now, at market rate, that sand is worth somewhere between 280 and 420 million pounds. Right, so you can see why a silver spoon sucker like Philip Hughes Walker might have his head turned by a number like that. And that application was submitted, and in February 2013, planning permission was granted for a significant extension to the workings. And that's when the 5-year fade, or as we like to call it, what it is, the operation to get rid of Hazel from this family, seems to have started. Now, Hazel, being Hazel, had been busy in San Diego setting up an organic skincare business whilst raising a child. She did the front of house, the retail, the marketing. Philip Walker took care of all the finances, all the money, including Hazel's. They didn't want to share the sand money with an outsider, you see. That's what it looks like. That's the 5-year fade. It was the plan. They seem to have named it after a golfing shot. Those of you who play golf will be familiar with the 5-yard fade. And Philip Walker was a keen golfer, like many a silver spoon rich kid before him. The divorce took place in San Diego. It dragged on for about 4 years. And in the course of preparing for it, Hazel found out that Philip had divested himself of a large number of Archibald Bathgate shares without telling her, and he'd divested her of her role in the company using a forged document. He sold their house in Cheshire for a lot less than it was worth for some reason. She discovered offshore accounts, extra hidden income, all sorts of things. She calls it a long, winding road of betrayal, and we can really see why when you look at what these people did to her. Shortly afterwards, she discovered a number of highly incriminating documents, and it was not long after that that her car was hit by another one while she was stationary at an intersection. This was at 75 miles an hour. Now, by 2013, when that planning permission for the quarry came through, what was going on, we think, is that Philip was running a script. It was one that had been written by his father, in our view. And by the time that divorce went through, from a husband whose family had access to hundreds of millions of pounds of resources, Hazel ended up with zero. Nothing. Not even a tiny flat. How does that happen in a fair legal system? Well, it doesn't, does it? It happens only with the help of corrupt judges. It started in San Diego, and then Hazel made the cardinal sin that we've seen, the cardinal mistake that we've seen lots of people make, and she went to seek redress in the English courts. She filed what's called a Part 3 claim for financial relief in England after a foreign divorce. She was unrepresented, she was disabled. There was another mysterious car crash in 2021, by the way, again, while she was stationary. And this time she broke her wrists, her hands rather, and she herniated her spine. And that one prompted a district attorney in San Diego to start talking about attempted murder. This was the second time Hazel had been hit in her car at speed while stationary. Obviously, in the course of preparing for this divorce, she'd been asking questions about the money, as wives who are getting divorced tend to do, and she had found stuff. She got nowhere in California, But here in the UK, to meet her needs and get representation, she asked for disclosure. And that's when we believe someone with a lot of clout pressed the panic button. And what happened next is the most egregious example of judicial corruption that we've seen since we started doing this kind of work in 2023. We spoke to Hazel on Zoom about it earlier today. This hearing on the 15th of February 2024, what actually was the hearing for?
Okay, so the hearing was for my financial remedy proceeding, where I'm seeking my needs for housing and disability care.
But it was a
Following my
directions
foreign.
hearing in your Part 3 claim,
Yeah,
basically, wasn't it?
it was. Yeah, it was a directions hearing to take me through to the final hearing, so the court could find out what was needed, disclosure, experts, things like that. So that's what it was for.
And you'd applied for a fair amount of disclosure ahead of this hearing. Just tell me about that briefly.
Yeah, what had happened was I'd actually been to court, and the court had awarded me something called the legal services order. And that was where my ex-husband, Philip, had to pay some money towards my legal fees. Well, I didn't have any money for legal fees, so he had to pay that. So the court had awarded me around about just over £6,500 a month, roughly, so I could be represented. And I'd been using that for around about 6 months, and it had run out. And the court had given me permission to apply for a renewal of that, so I could carry on having my representation. And the problem sort of happened really was that my lawyer, who I'd been with for a long time, since 2018, applied to renew that application, and really it was just completely ignored by the court. They just wouldn't deal with it. I ended up having to go as a self-represented party in October that year. I did actually go to the court and ask, could I just have a 1 hour hearing, a 1 or 2 hour hearing, to get that legal services order paid, because I really needed help.
But they
And
insisted on a 1 day hearing, a full day in this
or they
hearing in
denied
February.
it. Yeah,
Right.
they actually denied my application and said I had to wait 6 months without any representation. And it meant that I had to turn up at this hearing in February, which was a big directions hearing, for a final hearing, which was very complicated. So what I did was I
So
did
they
my
starved you
best.
of funds for 6 months, basically.
Yes,
And then there
pretty
was this
much.
hearing in February. Just tell me, so you're going there unrepresented, you're disabled, you've had no money for 6 months, and you walk in. Just tell me what you remember about the judge and about what happened in the morning. We'll come on to the afternoon later, but just tell me what it was like that morning and what the judge was like and who the judge was and stuff.
Okay, so I was very I was very nervous about going into court, because Philip had, very good representation. He had a counsel, he had a KC that was working on his case, and he had a lot of lawyers working on his case, and I was on my own. So I was very nervous, but I did manage to do quite a good job on a disclosure application before the hearing. The orders were that I had to do, if I wanted an expert, I'd have to ask for it. If I wanted a disclosure, I'd have to ask for it. If I wanted anything else procedurally, I had to ask for it, and I did that. And what had happened was I'd actually discovered some very incriminating documents showing that Philip had got a large amount of money in what appeared to be a hedge fund, around about £50 million. And I was trying to get this disclosure. And I'd also found forgeries of my signature on English bank documents that I'd never seen before. And I'd asked for disclosure of that. So before the judge, there was a disclosure application pending, and that's what I was hoping to deal with. But I was very nervous. I unfortunately, because I've got quite a lot of medical conditions, I've also got an anxiety condition. I get very nervous, and I'm quite frightened of Philip. I'd got a restraining order against him in California for a period of time, and I was just frightened of him. So I'd asked for accommodations from the court for my disability, and that I wouldn't be seeing him, and I'd have some kind of support, to get me through the hearing, and that hadn't been addressed.
So
So
you're in there.
when I turned up, I turned up sort of cold on my own, and nothing had been done to assist me.
you're essentially, so you're in a vulnerable position, is what you're telling me. And you're trying to draw the judge's attention to various things. This extra 50 million quid being one of those things, and the
That's
judge
right.
really just wasn't. He wasn't very sympathetic to you as a litigant in person. He'd just tell me a bit about his manner.
Well, the first thing was that Philip's lawyers had actually filed an application around about, I think it was about 6 days before the hearing. I mean, this is a hearing that had been on the record for 6 months, and 5 or 6 days before the hearing, they filed an application to dismiss my claim, to set aside my claim. This was a directions hearing. It wasn't a hearing for doing a set aside.
Sure.
But what happened was the judge sort of went straight into this set aside application, even though it wasn't the purpose of the hearing. And there was a big problem in the fact that where I was living, I don't have bandwidth. You know, I had a cell phone, no computer. So I was emailed a link that I couldn't open. Also, Philip's lawyers had asked to increase the bundle size of evidence. That's the evidence before the court. I hadn't seen it, and it was increased to well over sort of 600 pages.
Increased
And that
by
had,
600 pages or to
I think,
600 pages.
I think it was originally it was around about a 300-page bundle, and it went up to something like 600. I know
And
it's a
that was the
huge
day before
amount.
they sent you that, basically.
So the bundle was increased 1 or 2 days before. I couldn't open it.
Hmm.
I couldn't download it. So I
Hmm.
didn't have a copy of it when I got to the hearing. And I explained this to the judge. And the judge actually said, well, actually, I haven't got the bundle either, because I couldn't open the link either.
Hmm.
So he had to go
Hmm.
away and get the download the bundle, but I didn't have it. So I didn't have a bundle in front of me. I didn't know what it was. And I understand that's not, that's not procedurally right. I shouldn't have been put in that position. I didn't have any opportunity to put into the bundle properly. I didn't have any opportunity to read it, see what they were talking about.
So it
So,
sounds like they're trying to sort of get on with this thing without much sympathy for your condition, basically. Just tell me what happened after the lunch break.
well, just one thing to mention just before I go on to the lunch break. There was a very large television screen that, because my ex-husband is still in California and he appears remotely, and his face was on this screen and it was very large, and I'm frightened of him. So having this screen at the side of me with his great big massive face next to me really caused more distress. And because I can't take anxiety medication, it makes me very muted. It makes me I can't answer questions and things like that. I had to stop taking my medication. So I was in a position of real vulnerability, not being able to take my medication. And I'd explained this in the proceedings earlier. So I was in I was in a sort of a very nervous, agitated state. And what the judge did is he said he wanted to have a reading time, an hour's reading time. He authorised the bundle because the bundle hadn't been authorised. So he agreed that bundle could be authorised at the hearing, and he just accepted it. I didn't really get an opportunity to say anything about that. I didn't understand that I could object to that properly, but I just did tell him that I didn't have the first bundle, let alone, the extra pages. But he authorised that. So he went off for an hour to read. And I believe that I just sat inside the court, waiting at that stage. It's the best of my recollection. I was just waiting to be called back in again. So I went back into the court then, and
After
um,
lunch, you mean now?
this was after the 1 hour reading time.
Hmm.
And then the judge really embarked on an exercise which was very obviously directed to set my application aside at this hearing. And I objected as strongly as I could, really. But the judge wouldn't let me speak. He was giving Philip's counsel, who was called Amber Sheridan. She was really getting sort of the lion's share of the time, and I wasn't being able to speak. And she was speaking for a long time. And because of my conditions, when I broke my neck, I got a head injury. I've got, difficulties in sometimes, making notes on things. I was trying to have a 1 hour argument and then trying to address all those points. I just wasn't going to be able to do that. So I was constantly trying to say, I needed to speak. So when I was allowed to speak, the judge was really just kind of interrupting me constantly, wouldn't let me finish a sentence. It was very difficult, and it was very clear that the purpose of the hearing was going towards throwing my permission for the application out.
Well, that all sounds really, really stressful, Hazel. But you went out for lunch, and it was what happened when you came back in. That is the most concerning thing about this story. Can you please just explain to us what happened after the lunch break?
Yeah, sure. So I just went for a cup of tea during the lunch break, and then I returned to court, back into the court, and there was three lawyers at the back of the court, and the counsel and myself, and we sort of went back into the same position, the same situation where I wasn't able to speak. I didn't have a bundle in front of me, and the judge was just not letting me speak. And I just knew he was going to throw my case out. I just knew it was rocketing towards him throwing my case out. And I knew I wouldn't have anywhere to live. I'm sorry.
It's okay.
So I was trying to put the brakes on. I was trying to tell him that, it wasn't the right thing to do. It wasn't the right procedure. I said I didn't understand what was in front of me, what they were arguing. I remember saying to him something like, I just don't understand this. I'm overwhelmed by it. I don't understand. And he said, oh, I'll speak slowly. As though, I was a moron. And, I felt so, diminished by that. And I just continued to keep trying. And I just wasn't getting anywhere with it. And I could just see what was happening. And it just didn't feel right. I started to feel sick. I started to shake. I felt that the room was starting to spin. I felt really unwell. And I said to the judge, this is an 8-hour hearing on my own. We'd only been in proceedings for about an hour and a half, by the time you'd taken out the lunch breaks and his reading time. So I said, look, I need a break. I just need a break. So he said, okay, we'll give you a break. And the clerk got me a glass of water, and he went out of the courtroom, and Philip's lawyers went out of the courtroom. And I just felt so unwell, and the clerk opened the window, and I just couldn't breathe. I felt like my chest was going to burst. I thought I was having a heart attack. I really felt so ill. And I just said, I'm going to have to go to the bathroom. I think I'm going to be sick. So I left the courtroom. And I don't really remember anything after that, to be honest. The next thing I remember, I was opening my eyes, and there were 3 or 4 paramedics standing over me in the toilet. And they were putting me onto like a gurney. I just felt so sick. I didn't know where I was. My head was spinning. I felt like I'd been hit with a hammer on top of my head. I just felt so ill. And then they told me they couldn't get me in the lift because, the thing was too long. And because I broke my neck and I broke my back when I had my accidents, they said I had to stay on this flat. And I was really frightened. I thought I might have done something else to my neck again, So I was really scared. I'm sorry.
It's all right. It's all right.
Okay. Sorry.
It's all right, Hez. Don't worry. Take your time.
I went to the hospital. They took me in the ambulance. I was blue lighted off. I think they gave me an IV, and morphine and whatever. So they took me to the hospital, and they took me in immediately for a CT scan because of my prior injuries. I've been hit by 2 cars previously. And so they diagnosed me that I hadn't done any neck fractures or any damage to my back, thank God. But I did have a head injury and I had a concussion. I was vomiting quite a lot, and I really wasn't well at all. And that's the last that really I saw of the court.
That was the end of the court case for you that day, being taken away in an ambulance, and we think that was probably around 1:30, 2 o'clock, or definitely sometime after 1:30, anyway, but not
Yeah,
long after.
I think it was probably about 2 o'clock when the
Hmm.
hearing, 2:30 when the hearing finished.
Yes,
I think
right.
thereabouts.
Now, what Hazel has just described is not a procedural irregularity, it's not a grey area, and it's not a matter of judicial discretion. Let me be absolutely precise about this. When a litigant in person, that's a person representing themselves in court with no lawyer, is removed from their own hearing, there is exactly one lawful course of action available to that judge, and it's to stop the hearing, an adjournment. That's it. There's no exceptions to that. And here is why. Article 6 of the European Convention on Human Rights guarantees every person the right to a fair hearing. Right? A fair hearing. Not a hearing, a fair hearing. And that right is not suspended because the hearing is inconvenient for the legal professionals in the room to adjourn. It's not suspended because an order was almost ready. It cannot be suspended at all. Now, the Court of Appeal has been very clear on this. In cases involving unrepresented litigants, the judge presiding over a hearing involving a litigant in person has an extra duty, additional responsibilities to ensure a fair hearing, precisely because that person has no professional in the room to advocate for their rights. There's also a principle that's been at the heart of English common law for centuries. It's got a Latin name, audi alteram partem, and it means let the other side speak. You cannot make a binding order against a party who wasn't represented at the hearing. It's nonsense. Every lawyer knows that. Hazel Walker was not absent by choice. She was not absent through negligence. She was not absent because she failed to attend. She was carried out of the building by 5 employees of the London Ambulance Service. And then there's the Equality Act 2010. Hazel is a disabled person. The court had a statutory duty, not a guideline, a duty to make reasonable adjustments for disabled people during proceedings. The question of what adjustment was made when a disabled litigant in person collapsed in the courtroom has a simple answer in this case: none. Instead, the hearing continued, the directions were completed, an order was made, and the order was assembled in part on the basis of communications that took place whilst Hazel Walker was lying in a hospital. Communications she was never party to, never saw, and was never given the opportunity to respond to. Every single one of those steps was unlawful, not arguably unlawful, not unlawful depending on the circumstances, just unlawful. The judge in the room knew that. The lawyers in the room who were acting for Philip Walker knew that. The court staff in the room knew that. And that brings us to the question at the heart of the 5-year fade. Who was the judge in the room that day? Hazel, sounds like a funny question, but who was the judge that day?
Well, the day before the hearing, about 4:30 in the afternoon, they put a list out that you can go and see to see who your judge is. And every hearing I'd had a different judge. There was no continuity in my case at all, so I didn't know who was going to turn up. So on the listing, it said that it was a HHJ Robinson. And HHJ is a High Court judge, his honour judge, and that there hadn't been one of those in my case before. So I went onto the judicial website just to see, what his name was, because it just said Robinson. So I went onto the judicial website that afternoon, straight after I saw it, and I saw that there was only one judge who was a HHJ, and that was Graham Robinson. So I saw that, and I just assumed this was Graham Robinson. And then really that's all I knew when I went to the hearing.
And
So
just tell me, can you just from the best of your memory now, describe what the judge who was sitting there on that bench looked like?
he was a rounded face. He had like a greying sort of beard. He was a bit podgy, got a little bit like podgy. I think he was wearing like a dark coloured suit. I mean, to be honest with you, I was looking at him and everything.
Mhm.
I was, he was just a judge. Do you know what I mean? So
But over the subsequent days, you sort of recovered a bit from your head injury. You went home from the hospital, and you presumably started trying to find out, what had happened, what had been said, and then suddenly there were sort of draft orders coming your way by email and things. So you then had to deal with
yes.
all that. Just tell me about the
Mhm.
process where when you realised that Graham Robinson is not a family judge.
Yeah, I think what happened was because I'd obviously hurt myself and fallen, and there'd only been a very short time of the hearing that had gone by, an hour or so, and it was an 8-hour hearing. I assumed that what would happen is I would just go back. The court would say, you've got to come back and we'll carry on. There'd been adjournment. So that's what my assumption was, and someone would get in touch with me and tell me when I would be able to go back and we'd finish off with this judge, go back and see in front of him. And I came out of I got out of hospital and I came home, and it was the following day. And I got back sort of in the afternoon from the hospital the next day. I was very poorly. I was being sick. I wasn't well at all. And I opened my emails and I saw that what had happened was that Philip's lawyers had been, the case had just sort of finished, if you like. And there was an order. There was, the judge is looking for the order. The judge is looking for the draft order. There was these emails coming backwards and
Hmm.
forwards. And I wrote to Philip's lawyer and I said, "Hey, I've just got back from hospital. I can't look at anything like this. I need I need to have a couple, the weekend. I need to have some rest because, I've just had a really bad injury. I can't deal with this at the moment." So it made no difference. Everything just barreled on, and before I knew it, an approved order. There was a hearing,
Yes.
a hearing notice, and then
But this
in a
approved
very short,
order that you got,
yes.
it didn't have the first name of the judge on it. It just said
The,
H.H.J. Robinson.
No, what happened was that the first order that I got, it just said approved order in a PDF, and I have to the best of my recollection, I have to be honest, I don't remember actually opening it. I don't remember actually looking at that. I was so, I was so upset about the fact that it was just all carrying on without my involvement. I didn't really pay attention, and then a very short time after that, another order arrived, which was called a sealed order. So I'd already got an approved order, and then I'd got a sealed order. I thought they were the same thing. So I looked at the sealed order. I did look at that. It was lots of information in there, and lots of things that in there that I didn't agree to, that I didn't know anything about.
But
There
my
was an undertaking
understanding
in
is
there.
my
Yeah.
understanding is that the approved order you got had the name Richard Robinson on it, and the second one that you got had Robinson on it, but with no first name. Is that correct?
That's right. Yes, that's right.
And at some point, you also received some communication from Ali Pitchford from Hall Brown. Can you tell me about that?
Yeah, sure. What happened was there was lots of communications coming that had been sort of copied and pasted into emails. The judges said this, or the judges said that, and I contacted Hall Brown and I said, "Hey, I need to see these communications. Where's all this correspondence with the judge? What's happening?" I was really upset that I was just being sort of extracted from everything, and the case was just barreling on without me. So I repeatedly was asking her for these emails. I said, I want to see the correspondence. And I was being fobbed off, really. It was sort of like, oh, well, we've told you what you need to know. We've told you what the judge has said. I said, I want the emails. I want the correspondence between the judge and your counsel or whoever, or you, so I can see. And it took quite a long time, several days before they would actually produce that. But I was insistent about it. And then they did actually forward to me some information, but I'd asked them to give me the original emails. I said, please give me the native emails, meaning I wanted them to forward them to me. not just to copy them,
No, you
But what
wanted
they
the
did was
natives, the EMLs or similar. You wanted the natives. You asked
I
for the
wanted the
natives,
natives.
didn't you? Yeah.
That's right. I asked for the
Hmm.
natives. But what I didn't get that. What I
You
actually
got a
got was
PDF.
I got an email from Hall Brown from Ali Pitchford saying, here are two emails from from counsel, between counsel and the court and the judge, and here they are, and they were just PDFs, not the original emails.
And they had Richard Robinson written all over them.
They did have Richard Robinson written on them.
So you've got the first order. Approved order they called it. You said that says Richard on it. The second one says no first name on it, and the PDFs from Ali Pitchford say Richard all over them.
Yes,
Correct.
that's right. Yes.
So at some point you must have realised that Graham Robinson is not a family judge.
Yeah. So looking back at the time, I was I was quite distressed, obviously, about the whole situation. Um, and I want, I really, can I have a little break, Callum?
Now there is His Honour Judge Richard Robinson. He was called to the bar in 1977 and he sat in the family division. He was a district judge of the family division from 2002. He was also a family course director at the Judicial College. He was responsible for training judges in family law across England and Wales. He was a circuit judge from 2018, sitting at Medway County Court. And he co-edited a practical guide to family proceedings. Now, that's the practitioner's handbook on how to do family law. This guy wrote the book on family law litigation in England. But here's the problem. The judiciary website records that His Honour Judge Richard Robinson retired as a circuit judge on the 1st of April 2023. Now, that's a hard stop on his career. When a circuit judge retires in England and Wales, their judicial office ends on the day of retirement. It's a legal termination. From that moment, they have no judicial power. They can't hear cases, they can't make orders. They're just a private citizen. There is a mechanism for retired judges to return to the bench. Under the Public Service Pensions and Judicial Offices Act 2022, a retired circuit judge can be formally appointed to sit again, but only by the Lord Chief Justice personally, with the concurrence of the Lord Chancellor. It's a positive act, a formal appointment, and like every judicial appointment in England and Wales, it's published on the official judiciary website. His Honour Judge Richard Robinson retired on the 1st of April 2023. On the 15th of February 2024, he had been retired for 10 months and 13 days. Checks have been made with the Judicial Conduct Investigations Office, which has confirmed that he did not have a valid sitting in retirement ticket for the Central Family Court in February 2024. On the day of that hearing, His Honour Judge Richard Robinson had no more authority to hear that case than you or I. Now let's talk about Graham Robinson. Called to the bar in 1981, appointed a circuit judge in 2005, authorised to sit as a High Court judge in 2008. He was the designated civil judge for South Yorkshire and Sheffield from 2011 to 2023. Now, by any measure, this guy was a serious civil judge. He'd done a lot of criminal work actually, early in his career, but by this time, he was a serious civil judge. He was not a family judge, and he was not a specialised financial remedy judge. He did medical negligence, personal injury, workplace accidents, high-value commercial disputes, that kind of thing. Graham Robinson has done all of that, and that is actually all Graham Robinson has done, apart from a bit of criminal early in his career. The Sheffield Star interviewed him about his life and times in 2017. Now, there's a lot of guff in this article about the incorruptibility of judges, absolute hogwash, as any hunt and gather viewer knows. But it goes on and on about the things he's done and the things he thinks and the things he says. And it does not mention family law once. The JCIO told Hazel that Graham Robinson had been moved to Grimsby in early 2024, and he retired on the 1st of July that year. Now, a circuit judge is not a Swiss Army knife. They specialise, they're like doctors. You can't just wander in because you're a judge into any court you like and start hearing cases. A family judge needs a family ticket, a criminal judge needs a criminal ticket, a civil judge needs a civil ticket, and so on. Graham Robinson does not have a family ticket. He's never had a family ticket. His entire 23-year judicial career is criminal and civil. And he sits on the Northeastern Circuit in Sheffield. The Central Family Court is in London on the Southeastern Circuit. Sitting outside your own circuit requires a separate formal deployment from the Lady Chief Justice. So on the 15th of February 2024, if Graham Robinson was in that courtroom on High Holborn, he was there without a family ticket, outside his circuit, without deployment authorisation, presiding over a financial remedy hearing in a Part 3 claim. Everything about that is wrong. Every single thing. So one of two things has happened here. You see, either Graham Robinson, a criminal and civil judge with no family ticket, sitting outside his circuit with no deployment authorisation from the Lady Chief Justice, presided over a financial remedy hearing in a court where he wasn't authorised to sit. Every single one of those things is a separate breach, and collectively they amount to the willful and unauthorised exercise of judicial functions, which is the common law offence of misconduct in public office. And if it was Graham Robinson in that room, then Ali Pitchford of Hall Brown Solicitors, who later told Hazel it was someone else, subsequently created and disseminated a PDF documents naming Richard Robinson as the presiding judge. That's the creation and dissemination of false instruments, and that's illegal under the Forgery and Counterfeiting Act 1981. So that's scenario one. Scenario two is that Richard Robinson, a retired circuit judge 10 months and 13 days past his retirement date, with no sitting in retirement authorisation from the Lady Chief Justice for the Central Family Court, presided over that same hearing without authorisation. That too would be the willful and unauthorised exercise of judicial functions, and that too would be misconduct in public office. There is no third option. One of those two scenarios happened. That's according to people who were there. And whichever of these two Robinsons was sitting on that bench, whichever one of them was there, retired or not, when Hazel collapsed and was taken out of the room by paramedics, that Robinson should have stopped the case. In not doing so, they willfully breached their duty to ensure a fair hearing for Hazel, and that would also constitute, potentially, misconduct in public office. Now, that was a breach of Hazel's right to a fair trial, fair hearing, rather, under Article 6 of the European Convention of Human Rights, as we've said. It was also a breach of their duty under the Equality Act 2010 to make reasonable adjustments for a disabled person, and it was a violation of one of the oldest principles in English law, audi alterem partem. You cannot make a binding ruling on a hearing when someone wasn't represented. It's a legal nonsense. Every lawyer watching this knows that. Right, now this is the Crime Watch bit. We badly need to speak to these two Robinsons, and we haven't been able to find either of them yet. So if anyone knows where they are, if anyone can give us any information about their whereabouts, we'd love to hear from you. huntandgathertv@gmail.com. If there are any court staff in the building that day who want to have a talk to us about what happened, it's always easier when we get given this stuff rather than having to drag it out of people. We've been writing to lots of people in the legal industry about this, lots of people in the family law industry, asking them if they know Richard Robinson. One man did get back to us, actually, this man here, Nicholas Allen, KC. He's a Deputy High Court judge, and he's the head of chambers at 29 Bedford Row, which is a prominent family seat. He wrote back to us, and he said he would be happy to cooperate with an investigation, so that's good news. We've told a judge about a crime in a major court in London, and he says he'd be happy to cooperate with the investigation, what you'd expect from a judge, really, but it's more than we got from anybody else. Here's the rub, though. He says he'll only cooperate with an investigation, quote, by official bodies such as the police, the Bar Standards Board, or the Judicial Conduct Investigations Office. However, he says, I do not consider that I am under any legal or professional obligation to respond to the questions set out in your letter of the 5th of May 2026, and it is unclear on whose behalf they are asked. On that basis, I decline to provide the responses requested. Now, this is disappointing from Nicholas Allen. We've told him about a crime that might have been committed in a court building, and his response, this is a Deputy High Court judge, is, no, you're not the police. Now, we would hope that Nicholas Allen, having been made aware of these facts, would have gone to investigate himself. We've given him some information that he can use to do that. Let's see what he does. We don't trust the police, the SRA, or the BSB, and we've got very good reason not to. Now, we're going to continue looking into this. We're going to make a full-length documentary series about it, and we're going to write a book about it, because it is just about the best story about the rock-consuming Britain that we have ever heard. And as for Hazel, you'll remember we told you about her working class work ethic. She's got all the receipts.